everybody. I'm delighted to introduce the Right Honourable Lady Justice Arden to speak to you tonight. She's one of the most senior and important judges in the country, sitting on both the Court of Appeal and the European Court of Human Rights. So without further ado, I'll hand over to Lady Justice Arden.
Indeed. Good evening, everybody. May I say how much I appreciate your kind welcome and also being here. It's a very long time since I have been here to speak in the Cambridge Union. I dread to think how long it was. So it's very nice to see you. And what I thought I would do is just speak for 20 minutes or so about some things about the way I've found the law and the career and so on. So that would give you, as it were, the incentive, I hope, to ask some questions. Because I think what would be really useful is to have your reactions, because I want to know from you what you think, for instance, about the way we write judgments or carry out our role, and see whether I can answer your concerns. But what is life like to be a judge? Well, you start off generally by being an advocate, and most advocates are at the bar. I wanted to tell you a little story to illustrate the nature of life at the bar. Some of you may know because you've done many pupilages, but the story is not about barristers, it's about Winston Churchill. Winston Churchill and George Bernard Shaw were great friends, and they used to tease each other mercilessly. And when George Bernard Shaw had an opening night for a play, he sent Winston Churchill 2 tickets. Mr. Churchill, here are 2 tickets, one for you, one for your friend, if you have one. To which Winston Churchill sent back a reply, "Dear Mr. Shaw, I am returning your 2 tickets. I'm very sorry that due to a public engagement, I cannot attend the opening night of your new play, but please send me 2 tickets for the second night, if there is one." But that's the sort of joking and banter that you find at the bar, and I believe probably in solicitors' firms as well these days. In other words, the life of the law in the professions is a really enjoyable one, and one which, if you're headed that way, I am quite sure that you will enjoy. Now, how did I get into the law? Well, when I was at school, which was in the 1960s, if you believe that, we didn't have career departments, and we were expected to find out for ourselves what career we would like to follow. And the best example that I could think of was my own parents. My father was a solicitor, his father had been a solicitor, and my mother had worked with my father before she'd got married. And my father had a great instinctive feel for the law and would explain it and how it worked and what the principles were and so on. And he also had clients come to the house so that I'd got to see how the law was conducted. I worked in the office that he had some holidays, and so I got another feel for that too. So I decided before I left school that I would like to be a lawyer. And then I was lucky enough to get a place at Girton, so I spent 3 years there. And then I liked it so much I spent a 4th year there. And then in my final term, I decided that I wouldn't be a barrister, I wouldn't be a solicitor after all, and join my father's firm. My father had this great ambition that the firm would then become Arden, son and daughter. I would have to tell him I wanted to go to the bar after all. And that's because the bar, at least then, offered much more prospects of going on to being creative in the law and to deciding what the law is, which is what I now do. So at the end of the 4th term, I told my father. He was actually very, very good about it and quite pleased. And he couldn't not be, because in the area where I grew up, which was Liverpool, there were some very able women practicing the law. Most notably, a woman called Rose Heilbronn QC. She was a woman who had come to the bar shortly before the war and had been an astonishing success at the criminal bar, and she was regularly in the newspaper. And those are the days when the newspapers really did report court proceedings. Miss Heilbronn said this in defense of so-and-so, and she was much respected. So there was a role model there, which was certainly a role model for me. So when I found that I was going to change to be a barrister in my 4th term, I then realized I had a lot of dinners to eat before I could be a barrister. And so I decided to go to Harvard for a year, which I did because I could then eat dinners in absentia, if you understand me. And I had the most magnificent year in Harvard, studying subjects such as jurisprudence, which I had never done at Cambridge. And there were many, many eminent scholars who were giving lectures, including Lon Fuller in jurisprudence and Jack Dawson in restitution. Again, not a subject I could do here in Cambridge, and so on. So then I came back and I thought, it's all going to be easy now because I've got all these qualifications and I've got much better qualifications than my male colleagues. Was it easy? Not a bit of it. I managed to get pupillage through good luck, because somebody knew somebody who was prepared to twist the arm of a barrister to take me as a pupil. The person who was doing the twisting of the arm was a solicitor, so I got the pupillage. And also I was lucky in this way that the chambers where I was to be pupilled had just had a refurbishment, and for the first time they had not just a men's cloakroom but a ladies' toilet as well, so they felt from then on they could take a woman as a pupil, and I was there first. It was a very happy year, but I didn't get offered a tenancy at the end of it, not straight away. I went round other chambers, and the usual answer was, well, we've got a woman already, so you better ask somewhere else. Men won't instruct a woman in the area of work you want to do, which was company law. Now, I think those things are now out of date. I hope they are, and there are lots of women at the bar making their way. It's a hard career. I had 22 years at the bar before becoming a judge, and in the course of that, I became a Queen's Counsel, which was a career which opened many doors. You did lots of interesting things as a silk. You did inquiries, you went abroad to do cases, you advised people in many different walks of life. So that was great fun too. But then I was asked to be a judge in 1993, and I became the first woman judge of the Chancery Division of the High Court. It took them 15 years to find the second, which is perhaps a point one should bear in mind when thinking how few women we have in the judiciary. I was by that stage married. We had 3 children. My husband was also a barrister, and he became a judge shortly after me. We became the first High Court couple, and then the first Court of Appeal couple, and then, as you know, he went on to the Supreme Court, and I am in the Court of Appeal. Now, what exactly does the Court of Appeal do? Well, we have 2 divisions, civil and criminal. I only sit in the civil, and I do a wide range of civil work, although I've come from an area of the bar which is really very specialist. I have to do everything from immigration, housing, property law, company insolvency, whatever, whereas before I had a very much narrower line of practice. There are 42 members of the court, and we hear about 1,200 appeals a year. We dispose of that number, and there are many more applications as well. Now, you might be surprised to know that actually many of the cases in the Court of Appeal are really quite minor. They concern perhaps somebody who's a tenant in social housing who wants to establish some right they've got under the statute. But don't be deceived, it's often those little cases which go on to make a great deal of law. It's from small acorns, mighty oaks do grow. And we care just as much about those little cases as we do about the cases involving Berezovsky or some Russian oligarch. What happens when you decide those cases? They'll have come to you in the Court of Appeal because there isn't enough law already. And you have to decide some new point, you have to decide what the statute means in a new situation. And that when you've decided that case, other people will read it, and it gets more cases then will follow that case, and then year on year, that little case becomes really quite a big case. It all snowballs, in other words. So it doesn't matter whether you're doing a big case or a little case in the Court of Appeal. They're all as interesting, and they're all as important. Now, as I've just said, cases come to the Court of Appeal mainly because people have found out that they don't know what the law is. There are cases where there's a problem with the facts and they don't know quite what the facts are and whether the judge made a correct assessment. But in many cases, they come to us because the law has simply run out and we have to decide what the law should be. And I want to try and get across to you just how much discretion judges have. We call it judgment, but just to give you an idea of it, take the story of the woman with the violin. A woman has a nice violin and she has 3 children. Not necessarily her children, they were just 3 children. And the first child says, "Please may I have that violin? I've never learnt to play an instrument and I can make best use of it." And the next one says, "Please let me have it because I'm the best violin player here and I would make the best use of it." And the last one says, "Well, you should let me have it because I can actually pay you a decent price for it." So how do you choose between different people's needs? You're making value judgments all the time in relation to the law when you're dealing with questions of trying to work out what the law should be in a new situation. So in some situations, you will be deciding that people should share in something according to their legal right. So if somebody has a property right, the court will be concerned to vindicate that right. But as you know, that can lead you down a difficult path. If you remember the case of Bradford Corporation and Pickles, anyone remember? Mr. Pickles lived just outside Bradford, and Bradford was a growing commercial city, and it needed water. And they spotted that the best source of water was on Mr. Pickles' land. So what they proposed to do was to abstract the water from his source and build a reservoir. And what Mr. Pickles did was he said, well, actually, I'm going to divert that water flow somewhere else on my land, so you can't have it. And they took the case all the way to the House of Lords, and they said, well, we've got a statute which empowers us to take water. And the House of Lords said the statute doesn't work, and in any event, the mere fact that Mr. Pickles is trying to do you down out of vengeance is not a reason why he can't keep his property right. So there are certainly situations where you find that people are exercising property rights in their own selfish interest and not in the interests of society. So are there any situations in which you can divide up what's to be divided according to interests of the society? Well, sometimes the law does allow that situation. Take, for instance, immigration. In immigration, somebody may have built up a private life here because they've been waiting to hear the result as to whether they're going to have an asylum claim accepted or not. They lose it. Then removal directions are served. They say, Article 8 of the European Convention, I have a right to private life, and removing me would certainly interfere with my right to private life. And then you have to say, yes, your right is certainly interfered with, but there's an exception in Article 8.2 which we have to consider, which says that in some circumstances your right can be interfered with. And one of the situations is the protection of the rights of others and the welfare of society. And of course, in that situation, we have to weigh up the immigrant's right to the potential immigrant's right to a private life, it's an overstay, as against the right of society to enforce the law on immigration control. And in each case, you have to do that balance. So that's where you're trying to decide a case on another basis, namely that the interests of society are important. So there are all sorts of considerations. And then you might have a situation where you have to consider a person's needs, that they would get a result according to their needs. And this may have been one of the factors, is likely to have been one of the factors, behind decisions like Fairchild and Glenhaven, if you remember that. That's the case where a man had been employed by different employers over many years, and then after he'd ceased employment, he found that he had asbestosis, which is a horrible, horrible industrial disease. But he couldn't say which of his employers had caused him to inhale the asbestos dust. It could have been any of them. And what the House of Lords did was to say they're all liable, even though, of course, he couldn't prove that any one of them was liable. And that's a situation where the law is giving a remedy because a person needs a remedy. There's no insurance in that situation, and a person needs to have compensation for that terrible illness. So now, I just wanted to get across to you quite how much discretion, judgment there is in the job of being a judge, and how much we think about each individual case. Unless the answer is perfectly clear and parties have made a mistake, the law is clear, then we'll have to think about these things quite carefully and write them up in our judgment. So what I would like to know is from you, we might have some reaction to this. Those of you who are law students presumably do from time to time read our judgments. I don't suppose you see very much of this debate going on because we express the judgments in terms of the decided cases and the precedents and the statutes and all the rest of it. But I would like to know quite how accessible you feel our judgments are. There is a school of thought that we simply write our judgments for the two parties and for fellow lawyers, fellow judges, and academics, not usually for students. There's another point of view, and I think it's the one I prefer, that you write the judgment for a much wider audience. You write it for people who might come along and say, I'm reasonably interested in knowing what the law is about. I'm reasonably well informed. I would like to read this And I don't want it to be over technical. I don't want it to be full of jargon. I want it to be laid out in a way which, even though I'm not a lawyer, I will understand. So there is this debate going on, and I would be very interested to know how easy you find it when you're asked to read a judgment, or whether you think we should change. I should say that there are probably not many people in the category I've just referred to who are not lawyers who want to read judgments. As somebody put it to me, there aren't many chaps in anoraks in bedsits who spend their time reading Court of Appeal judgments. But it seems to me that's not the issue. The issue is they might want to do so, and they do from time to time want to pick up a judgment, and they're entitled to know what the law is. So that's a question you might like to contribute on. So some of you will be going off to be practicing members of the profession. And I have to say, it's a profession going through an enormous amount of change. As you know, we're in a period of austerity. Public funding for litigants is being cut. And the result is that many people who would previously have been able to run cases on the basis of legal aid cannot now do so. And there's a very severe effect on members of the criminal bar in particular. They're actually having their fees that they normally receive cut drastically. So I'd say something like 30%. And there are barristers who are leaving the profession and going to join solicitors' firms, staying in the law, but going to join solicitors' firms. And you have to accept that the bar is very large. It's too large. There are many more people who get called every year than find pupillage. And there are some barristers who have in the past been able to earn substantial fees. I don't think that's true now, but I think they were overpaid by the public system. Speaking as a judge, I think it is really important to have an independent bar, because when somebody is accused of a criminal charge, it is very important that they should have somebody standing up, testing the evidence, investigating the documents, and making sure that person has the best chance of being acquitted that is possible. Because it's a very serious thing to be convicted. And it is also, I think, serious for society if we don't see people are properly defended. It puts the government in too much power over us. And so I hope very much that the criminal bar will not be too badly affected. In civil cases, we're also very dependent on the advocates, because they will come along. There's no better way to test an argument than to have two people on either side. You must know that here, because you have two people on either side of the debate. And getting the legal answer, you test it and you refine it in the course of argument. So I think it's very, very important that we keep an independent bar. And if you become advocates, I will be very proud of you, because we do need you. Now, that's what I wanted to say about the Court of Appeal in general, about the profession in general. I just wanted to give you some insight of some of the themes that have illuminated my career. And there are four I'm going to talk about. First, law reform. I have a saying for myself, which is that once a law reformer, always a law reformer. I've always been involved with law reform. It gives you a different approach to the law, because you're looking at a subject in an overview and seeing whether or not it matches up to modern day expectations. I had an opportunity to sit on a law reform committee while I was a barrister, and I did that for 20 years. It gives you an immense interest in the law and immense breadth in the law as well, and the habit of looking critically at the law really never leaves you. But I had another opportunity as well, which was very welcome, and that was to become the chair of the Law Commission of England and Wales, which is a statutory body set up by Act of Parliament, and it runs projects in agreement with the government about the reform of the law. It's a highly independent institution. The recommendations are worked out by the four commissioners together, and we have a bunch of young lawyers at the Law Commission. It was a great period, and I did indeed learn a huge amount there, not only about actually how you critically examine law, but also how law is made by policy makers in Whitehall and then by legislators in Parliament. It was a case of seeing the law in all its processes, and also seeing people who were affected by the law, consumers who came along to complain about the law, or professional organizations and so on. Great period for enjoying the law. When I was there, I did a particular project which linked up with my university career, and I thought that might be interesting to you. When I went to Harvard, you all had to do a thesis, and I suspect you do a thesis now in your 3rd or 4th year in Cambridge. And I chose to do it in an area which is pretty hidden from view, called derivative actions. It means that when a shareholder wants to sue the directors, they sue on behalf of the company, but as individuals. And it's quite important because it keeps the directors on their toes. These things are very common in the States, and I couldn't explain to my American professors why it was we very nearly never had such an action here. So I wrote my thesis comparing English and US law. And then when I went to the Law Commission, I found that the project they wanted me to do was a project on derivative actions. So I was able to pull out the thesis and produce a Law Commission report, lots of comments and help from the Law Society and the Bar, and I did it in conjunction with the Scottish Law Commission and the Northern Ireland Law Commission. We produced recommendations which the government accepted and which were incorporated into the Companies Act 2006, which some of you may have had to suffer. It is the longest statute in British history. It had the highest number of amendments, but there's been very little challenge to the provisions which the Law Commission did in my day, namely those on derivative actions and another set on directors' duties, which were very important in practice. And for those, I had help from Simon Deakin, who is a professor here in Cambridge, because we looked at it from an economics point of view. He's at the Judge Institute. So that's one area of life, modernizing and simplifying the law. That's a theme which I would like to say is a theme of my work, that I'm looking to modernize and simplify the law, not just to do it as a black letter job, but to modernize and simplify the law. My second theme is serving the needs of society, by which I mean principally keeping the law up to date. And I've really only time to talk about one aspect of that, and that's human rights. Human rights has undoubtedly been the biggest change in my career. Before 2000, people in my position would simply not have known about the convention. We would have had no experience, we've had no knowledge about its jurisprudence. And so it was a great opportunity. And what I did was I just finished at the Law Commission. I had a whole bank of leave due to me. So I went off to Strasbourg and I sat in the court and I worked on files and talked to the judges. And I came back fully armed and enthused about the convention. I'm sorry there's all this debate about whether we should stay in the convention. We certainly should, because it has produced some very beneficial jurisprudence. And I can give you 2 examples of that. One, terrorism. After the Human Rights Act became law, we had 9/11, and then we had the cases which arose in England because the Home Secretary put aliens whom she suspected of terrorism into detention. Didn't put them on trial, she put them in detention. And the judges had to consider the legality of that particular legislation, whether it satisfied the Human Rights Act and so on, and they held that it failed. But we could never have done that. We could never have really raised the standards of a free society in that way without the convention. And the second area where the convention has had an enormous impact, in many areas, but second I wanted to mention was in relation to privacy. As you know, before 2000, there is no way that the judges could protect anyone from an invasion of their privacy. You'll remember there was a case about Gordon Kay, an actor, who was injured when a tree fell in the Great Storm of 1989. He was driving in his car and he suffered a most terrible head injury when the tree fell on him. And while he was in hospital, 2 red-top journalists went along and interviewed him and then wanted to publish this rather odd interview they'd had with him, which was very distressing for his family, and it would also have been very distressing for him. And the Court of Appeal, which was in a constitution chaired by Lord Bingham himself, held that there was no remedy because it was simply an invasion of privacy, and English law didn't recognize a remedy for invasion of privacy. After the Human Rights Act, the courts were able to draw on the jurisprudence on Article 8 and Article 10. Article 8, right to a private life. Article 10, right to freedom of expression. 2 rights that have to be balanced together. And to say that when somebody seeks to publish some information which is purely private, no public interest, then it's a breach of confidence. And so they developed the law of confidence to provide a remedy in privacy. Privacy was a subject on which Parliament had totally failed to legislate. There had been an excellent Law Commission report which they hadn't implemented, and there had been reports also from other great people on how to legislate for this problem. But we couldn't have done it without human rights. So that's another theme, responding to the needs in society. My third theme is international work. I am now the head of international judicial relations for England and Wales, which means I'm the judiciary's foreign secretary. So what I do is I meet a huge number of international judges and learn from them what the problems they're facing or how they've tackled their problems. And since the Constitutional Reform Act in 2005, I've been in this position because, as you know, there was then a separation of the judiciary from the Ministry of Justice, and we were left to do it for ourselves instead of it always being done by the Ministry of Justice. I've always regarded it as extremely important to test my own law by reference to what happens in another jurisdiction, because I think that's how you get a new perspective on your law. You then see it in perspective. You then see it for what it is. And I think it was Goethe who said, you never know your own language until you speak other languages. You get another sense for the way your language is formed by knowing how other people's languages are spoken and formed. And so it is with the law. If you look at our law, you'll see that sometimes we have an over-restrictive rule which we could adapt and produce a more sensible rule by following some other jurisdiction. This year I've done a paper on good faith. Good faith is not a generalized concept in English law. We have a number of special situations where you get a remedy which is equivalent to having an overarching principle of good faith. But if you look at other systems, there is an overarching principle. So I was trying to suggest that we might move a little bit, not very far, down that road. And I could only do that by using my knowledge of international law, of comparative law. So I have this very interesting job, which I do out of court, in addition to the other things that I do. And in the last 5-10 years, there has been an enormous growth in meetings taking place between senior judges in different countries. They could either be Commonwealth countries or European countries. So obviously countries where there's a big difference in language, a big difference in legal system. And we also have regular meetings with the two European supranational courts, the Court of Justice of the European Union in Luxembourg, and another one with the European Court of Human Rights in Strasbourg. And these are very valuable occasions for informal exchanges. I like to think that I perhaps have pushed judges down this road. It's a subject I have written about the importance of informal dialogue, and I think it may have been one of the reasons why the Supreme Court has now said that we won't just follow Strasbourg. We will, where the case law is not clear and consistent, disagree with them if it's in fact contrary to some fundamental principle of our own law. Now, the thought I want to leave you is this. You're all going to go into different paths of the law if you're going into the law, and for your first few years, if not the first decade or so, you'll be working extremely hard in your own area. But please don't forget how important British law is internationally and the huge cachet it carries, and be very proud of it and seek to expand its influence, because it is very important that you should do so, and that it's one of the ways in which the United Kingdom benefits and is able to bring a benefit to other people in other countries. So that leads me briefly to my fourth topic, which is statute law. And we're getting near the end, so I won't just say very much, but perhaps just leave you with a few thoughts. I've always been very interested in statute law. It's rarely taught in the universities, and that's why I'm not going to say very much about it. Our principal job is to interpret it. And obviously, we can't just rewrite the law or fill in gaps. We have to try and read what is there and make sense of it in situations which probably Parliament didn't think about. So what I have developed in my own writings are different ways, different techniques of interpretation. There's a great tendency in English law to say one statute's just like another, just interpret them in the same way. But I've developed a system whereby certainly there are some statutes which you interpret tracking the words as closely as you can, But there are other areas, like human rights, where you apply a dynamic interpretation because you're trying to give effect to a concept rather than simply a right written in language at a particular point in time. So you have to give it a living meaning. And most recently, I have been talking about devolution legislation. Some of you may come from Scotland, Northern Ireland, or Wales. You have devolution legislation in your own part of the United Kingdom. The Supreme Court has said that that should be interpreted like any other statute, but I have taken the view in writing about it that really it is constitutional legislation and you do have to give it a living interpretation, and why not recognize reality, which it is federal legislation, and we are therefore in a position to use the techniques which judges in proper federal jurisdictions use to interpret statutes and to help them to reach the right answer. None of that involves departing from Parliament's intention, because when Parliament enacted the devolution legislation, it did so with a view to establishing a new constitutional settlement. Take the example of Northern Ireland, where there had been the Belfast Agreement, and there was an enormous feeling that both sides of the community should be brought together in the new devolution arrangements. So those are the themes that have coloured some of my work at the bar. I hope that they will be interesting to you. I'm just going to leave you with some points because I'd like to hope that you will feel encouraged about the law. The first point I wanted to make was, remember that the law is for the curious. Never just take it as read. Always challenge it and stand up for what you think is the right thing. Secondly, when you're working in chambers or in your solicitor's firm, do be sensitive because people have very different ways of working. And if you're going to be a success, you have to be sensitive to that. Thirdly, remember that you are one of the best qualified generations of lawyers, so there's going to be incredibly hot competition, and just think about where you want to be and how to get there. And my last point is a very simple one. Please enjoy the law. It is truly an immensely interesting and stimulating career. It continues to be a satisfying career all the time. No two cases are alike, and it is something where you develop your skills all the time. It's not a career where you will find you'll reach a peak at age 45, 50, and then you'll be in decline and want to retire. It's not like that at all. So please enjoy the law. Thank you.
Thank you very much, Lady Justice Arden, for that very inspiring speech. Now, does anyone have any questions they'd like to ask? One here in the row.
Thank you for those words. I have the impression over the years, quite a few years in my case, that the frequency of recourse to judicial review has greatly increased. Is this, A, correct? And if it is correct, is it because judges have become more interventionist, or is it because governments have become more careless of the law, or is there some other reason?
Undoubtedly, judicial review has increased. And what I perhaps should have said, that one of the benevolent effects of the Human Rights Act is that in judicial review cases involving somebody's rights, the onus has shifted from the applicant for judicial review to the government. So the state has to justify interfering with your right. If once you establish a right, then they have to have the job of justifying. That's new. And also what's new is that you get a different standard of scrutiny following the Human Rights Act. If you've got a case involving human rights, it's a higher standard. It's what we call a more intense review. So is there now a rise in the frequency of recourse to judicial review? Yes, there is. And I would say that's because the legislation is much more complex. But I don't think judges are under any illusion. We're not the decision maker. The function of the court is to see that the correct legal process is adhered to. And we don't ourselves take the decision. We send it back to the decision maker. And except in the very exceptional situation where the decision maker couldn't have come to any other conclusion than that which we set out. There's very rare cases. So it is still respectful of the position of the executive and of the position of Parliament.
gentleman here on the left. Okay, please wait for a microphone as well.
Yes, thank you. You've talked very generously about your personal involvement with the law, and I think you've made it very accessible, certain aspects of your life, to the people in this room. But I wondered if you could develop a little bit more about your personal involvement with the courts, but looking away from them back at the people that those courts serve, and talk a little bit about some of the general trends of, for example, persistent resistance or prolonged apathy, and how over your career these mechanisms have changed. So it may be, for example, that the media motivates the populace to take up a certain cause, but looking back on your career, how have these general trends that have inhibited people seeking and in turn being given their justice? Thank you.
That's a very interesting question. There is one point that I would like to raise in particular, and that is we now have an increasing number of people who represent themselves, self-represented parties, because they simply can't afford a lawyer, or they can't find one who's prepared to do it on terms that they only get paid if they get damages and so on. So we have an increasing number of people, and that calls upon the skills of the judge. Very often we have applications with simply a litigant in person. You can't, as it were, step into the arena and make their case for them, but you can try and tease it out of them by saying, well, now, I think your point is this, and try and explain it for them, and then ask them how they deal with a certain point. And we're getting much more practice at that now. And there is another institution which has helped us, and that is that we have a system called the Personal Support Unit in the Royal Courts of Justice. These are people who are not lawyers at all. They're generally retired people who are prepared to come along and sit in court with the litigant in person, so that when the judge says, have you got page 100 of your bundle, they will say to the page 100 for you. And I have seen them, as it were, take the litigants in person under their wing. In some cases they are very, very distraught, particularly in bankruptcy and family matters, and just give them a lot of comfort. That helps us enormously, but it also makes us very aware of what a stressful process litigation is. And I'm afraid to say with the cuts in legal aid, there will be more and more, particularly in family cases, where people are really quite desperate because their children have been taken away. And we have to acquire skills of helping these people. I hope that's some part of the answer. It's a very big question.
Gentleman there in the third row.
You touched upon the citation of foreign law in the courts, and this is something that's, of course, been extensively discussed vis-a-vis the US courts, but not so much for the courts in the United Kingdom. So my question is divided into two parts. The first is, in what kind of cases would you consider citing foreign law, or foreign case law, I should say? And my second question is, when you do in fact decide to cite foreign case law, which jurisdictions would you turn to? And the reason I'm asking this is because there is a certain sense that there's some parochialism, if I can put it that way, that you'd look to, say, the United States and Canada and perhaps go to Australia and New Zealand, but not some of the other emerging jurisdictions such as South Africa or India, which have great socio-economic rights jurisprudence, for instance. So
certainly. There are a number of ways of using foreign law. And one of them is simply to use it to test your own thinking privately, and then not to put it into the judgment. It enables you to create a personal discipline. And that's a very good way of using foreign law. So you won't see it on the face of the judgment. We don't have any rules to say you can't do it. There is a body of thought in the United States to which you were referring called Originalism, which says that you have to interpret the Constitution in accordance with what the framers of the Constitution thought, which is probably rather difficult given that problems are constantly changing. It's also very unpopular in the States to cite foreign authority. And not so many years ago, there was a bill before the Senate which was intended to give power to impeach judges who referred to foreign decisions in their judgments on the basis that this was totally unconstitutional. They were American judges, so they applied only American law. That was one point of view. I think we would use it in order, if we were citing it, in order to give an additional piece of information which would help the reader of the judgment understand the direction you're going in. You are very dependent on what counsel and the advocates are prepared to give you. You can sometimes go and ask them, but they probably have much less experience in using comparative law than you do. So you're not likely to get very much. I'm very conscious about India. I'm very conscious of South Africa. In fact, in the lecture I gave about federalism, I wanted very much to use Indian jurisprudence, but because India is a federation. But the Indian Supreme Court is actually, as a court, it developed many of the doctrines of interpreting statutes in the early days. But India politically has gone the other direction of deciding it's not a federation, really, it's one country. So they have had less law recently. And South Africa, I've studied in South Africa, and there's some wonderful jurisprudence there about the right to health and so on. And if we were to get a Bill of Rights with some socioeconomic rights of a progressive nature like that, we'd be right in there.
Question? The guy in the front row here.
Good evening. One question. We understood your position regarding that the UK should not pull off from the European Convention. Nevertheless, it's still a debate, and I wondered, if the UK withdrew from the European Convention, what then? What's the role of the judiciary, in specific, in order to continue the protection of human rights of citizens and individuals in the UK?
We'd certainly continue to enforce fundamental rights of the common law, but we couldn't anymore use the convention, because that would have no effect in domestic law.
No, I understand, but I mean, apart from a legal answer, what should be done? What could we do? Or should we simply leave it just like that?
Well, perhaps I'm being Panglossian. I hope very much we will not leave the Council of Europe, because there are 47 members of the Council of Europe, including places like Azerbaijan and Armenia and Turkey, which need leadership in the matter of human rights. It is a great thing which the United Kingdom can do by being a member and by implementing the judgments of the court, because we can then expect other contracting parties to do so. I don't know whether you're aware of this, but the Council of Europe has this mechanism built into it. When the court gives a judgment, it's not like any other court that can't enforce its judgment. The judgment is sent to the Committee of Ministers of the Council of Europe, and they oversee its implementation. Now, it may take a few years. I think the record's about 15 years. But at the end of the day, if you want to be a party to the Council of Europe, you have to implement the court's decision. And it means that there are huge improvements for, let us say, prisoners in Russia. That position is still very dire. For Kurds in Turkey, and so on. And it's one way we can help on a humanitarian level in Europe by remaining a member. But at the end of the day, it's a question for the British people and for the Parliament, and we will do whatever Parliament tells us.
Do you have any questions from this side of the House? Here in the front row.
Lady Justice, thank you very much for your speech. Just really responding to your point about accessibility of judgments. Clearly, if one reads beyond the head note and reads the actual judgment itself, as obviously most people should do, I think one thing that's very useful, certainly from the things that I've read, is a brief précis or history of the kind of trends, the policy trends. So something I'm reading at the moment, the kind of the assimilation between common law constructive trusts and proprietary estoppel. Some of the good cases, and most recent cases in 2008 and 2009, in the House of Lords, go into quite an in-depth discussion of the history and the policy trends towards assimilation and against assimilation of those two doctrines. So I think in one respect, and of course one couldn't possibly enforce this across the judiciary and couldn't enforce judges to do this, but I think one of the valuable things that one finds in judgments is this précis of policy direction.
That's a useful point. Thank you. I hadn't thought of that. I'd like to think there are précis either at the front or at the end, but you don't always find them. Indeed, some members of the press ring up our judicial office, press office, and say, could you please tell us who won and who lost? Right. Is there another?
Just here.
As a first-year law student, I'm only about 4 weeks into my legal learning,
Right.
and at this point, it occurs to me that I come away from some cases, you were talking about accessibility, I have to double check with my other students, like, who actually won? I'm not sure, especially where there was, almost an equal number of, arguing for one side or for the other. Do you not think that the technique taken on by some courts now of giving a singular judgment as opposed to several individual judgments would make the law clearer, not for students or for practitioners, but if non-legally trained individuals are to read these judgments, I find it very hard to believe that they would be able to understand or extract any sort of singular legal principle, especially from the more complicated cases, which is very contrary to the idea that the law should be accessible to everyone.
Quite. The disadvantage, which you will discover, of single judgments is that they are the work of a committee. And when you get to do European law, you will see the single judgments of the Court of Justice, which have gone through a process of deliberation. They've no doubt been extremely carefully considered, but of course they can't contain what any member of the court doesn't want to be in there. And so there are great leaps in the reasoning where it might have been that something was taken out. So the danger of a single judgment is that you'll actually have a less accessible and certainly a less progressive document than you would do if people were able to express their own points of view. What happens in the Court of Appeal is a halfway house, which is that in most cases there is only one judgment and the two other judges will just say, I agree, or I also agree, and then they perhaps will have a few paragraphs and a few sentences, but the main judgment will still be the one lead judgment, so you don't have to go to the second and third judgments unless the point they've added is the key point that arises for you. That, I think, does aid accessibility, but there are lots of other things we should be doing, in my view. One of them is giving précis and just a roadmap through the judgment. Say somewhere near the beginning what areas you're going to cover, because you can, at some cases, you have to read on and on and on to find out where the judgment's going, what points it's going to cover, because there's no indication at the start. I suspect you're going to get very adept at this, and you will jump and skip, and you'll use your highlighter, and you'll pull out the right things. But I suspect there are some nights when you'll be tearing your hair out.
Thank you. And we've got the gentleman here in the blue shirt.
Hi, thank you. You mentioned briefly at the beginning of your talk that you studied jurisprudence, legal history in Harvard. Now, I've only started a jurisprudence course here in Cambridge, and I was wondering, I've noticed that among law students, jurisprudence is sometimes regarded as rather pointless or purely academic. And I was wondering how jurisprudence, how legal history influenced your working career, how was it professionally useful to you?
Right. I did take away quite a lot from doing jurisprudence with Lon Fuller. Lon Fuller had, for instance, this idea of the responsible lawmaker, whom he called Rex. And Rex came into his kingdom and he immediately wanted to revise the laws, but he made a lot of mistakes. And Lon Fuller said, well, he tried to make the law retrospective and it was unclear law and all the rest of it. And by doing this, he devises a theory of the inner morality of law, i.e. the law must be clear, it must meet certain qualifications, it must express certain level of morality, and you must be able to approach it with that in view. Now, I find that very useful in my working life, because when I look at legislation, I bear in mind those principles that statute law, although it seems to be dealing with a very practical subject, is actually using a lot of conventions. There is no retrospective legislation unless there's been some special reason, and so on. If I just gave that one example that I think I've taken away from my jurisprudence course, obviously I don't go into thinking about Kelson every time I think about things, but I do think that there is merit in staying with that course, that the general points will remain with you. I have also written an article about John Stuart Mill, saying that the ideas of John Stuart Mill are actually the ideas you find in Article 8 of the Convention. And I found that quite a fun exercise to do. His harm principle, that you can do what you want unless it harms somebody else, is very much like the philosophy in the European Convention on Human Rights, that you're entitled to exercise your right unless it has to be qualified for the purpose of the protection of others or morality or whatever it is. So yes, keep up with it. Stay with it.
Yeah, we've got the lady here in the second row.
Thank you. Two questions, one practical and one more theoretical. The practical one is, what are the qualities of the best barristers you've seen? Who are the most effective for those of us who aspire to join the bar? And the second question would be, you mentioned your enormous discretion. So when you're faced, let's say, with a gap in the law or an unsettled principle, what is the basis upon which you make a final determination? I understand this is value-laden and it might link back to jurisprudence, but what are the values and the principles?
Okay. On your question one, what impresses me about an advocate? Somebody who's thought the case through from beginning to end and can express it succinctly. So the best skeleton arguments are not the 80-page ones, and we don't allow those anyway. It's the person who's actually written it out, rewritten it, and boiled it down to its essential, and given you a crisp and convincing argument. And the people who impress you in oral argument are not the people with the flourishes and they're throwing around the glass of water and all the rest of it. It's the people who get down to it and convince you on a logical basis. And on your second question, what do you do if you have a gap in the law? Well, I would like to just give you one answer, which is quite separate from what ideas you may be bringing in. You have got to find a principled reason for your decision, and you've got to be satisfied that it stands up. It's a great virtue of having to give reasons for your decision. So you move progressively, therefore, from what has already been decided, and you try and work forward on a principled basis.
You've got the lady here in the front row.
Thank you for your presentation. During your speech, you mentioned that over the last years, we see the trend that British judicial system is being exported out from Britain to other jurisdictions. So, have you ever had the feeling that when people are subjecting their contracts or their relation to English law, they're looking for some kind of better justice that they can get in their jurisdiction? But when, for example, in Berezovsky-Abramovich case, when they got the decision, it might be not the kind of justice that they were expecting. So is there
well, we do like to think that we do produce a very high standard of justice, but I am not saying that there are not other systems which can produce the same result. And really, in my international work, there are 2 points. I go out to learn from other systems, and I go out to influence them. So if we've got a good idea, I want to explain it and say practically why it's a good idea. But likewise, I want to know about their system, because they may sometimes have a better way of doing things. And so I want to learn and to test my own system. Last week, we had the president of the Federal Constitutional Court of Germany in London, and that was a great honor. And he gave a speech in English, of course, a very impressive speech, and he kept on referring to cricket. And when he got to the end, he said effectively that learning in Europe was like playing a game of cricket. It is slow, it is difficult. Sometimes the best man doesn't win. And lastly, he said, it's like cricket. Life would not be as good without it. So you've got to remember it swings and roundabouts. That's all I'm going to say.
Okay. I think we've got time for a few more questions. So the gentleman in the front row here.
One of the things I found really interesting was the dialogue between the judges, the international meetings. I was wondering, but what kinds of things do you talk there? And a second part of that question, do you have any other form of informal dialogue with, for example, ECJ judges? Is there any national, supranational dialogue which I wouldn't know about as a non-judge?
No, I mean, I think national judges on supranational courts tend to keep in touch with their own judiciaries, and that's a very good move, because each side can learn from the other. There are several different sorts of dialogue. At a certain level, they're about judicial administration and judicial independence and all those sorts of issues. But at the very highest level, it's more about constitutional issues, how you approach new emerging problems, and your expected views on this sort of thing, or some new measure that's happening, or even judgment writing. It's at a very high and abstract level, but you learn an enormous amount, because obviously you are both coming at a subject as experts in it.
Okay, we've got the gentleman there.
Thank you very much. I was just wondering if you could say a little bit more about your experience in the Strasbourg court, and in particular, kind of the jurisprudential differences, the differences in thinking style and working style between that court and our domestic courts.
Right. And I could talk all night about the Strasbourg court, but let me just make 2 points. The first thing that hit me, and it may not have occurred to anyone here, is that when you go there, you realise that their caseload is not just about the United Kingdom, or even about Germany or France. It is also about Bulgaria, Romania, Russia, Turkey, all the 47 countries. And you realise the wealth of problems they've got to deal with, and how remarkable their jurisprudence is to be shining a light on all these situations. I can also tell you from having travelled to very distant parts of the world, even South America, that the jurisprudence of the Strasbourg court is held in very high regard. It is, I think, the premier human rights court in the world, and what they do is remarkable. About working methods, the judges work in a different way, because when you've got people, one national judge from each member state, so it's going to be difficult for them to sit down as judges all from, as if they'd come from one member state. And so what tends to happen is that the lawyers, who are experts, will write the first draft of the judgment, and then the judges sit down and discuss it. Now that is a difference, because we don't have lawyers doing that for us. You do in the States, but not, we don't have it. So that's another remarkable difference. Otherwise, it's just a very stimulating and inspiring place to be.
We could have a final 2 or 3 questions. The lady here in the red.
Just with regard to concepts and accessibility, just briefly. At the moment, I'm doing equity and the Vanderbilt litigation, and I find it confusing with numerous cases at the best of times. So how would you make it more accessible? How would you explain the concepts of things like trusts and, the general principles of equity? Would you make it like a textbook, but then that would make it possibly longer and even more complicated than it already is, and involving more jargon? How do you think would be the best way to solve that?
Well, there are different ways of solving it. I had in mind just making an individual judgment clearer, not a whole area of law, because I think judges wouldn't have time to do it. And anyway, I may say so, people who write the textbooks are rather better at it than the judges. But in a judgment, you could, as it were, at the start of it, say what the issue is in very simple terms without all this detailed fact. And then you could early on indicate what the answer was going to be and why you got there. Now, a lot of people think that's a bad thing to do because it suggests to the litigants that you've made up your mind before you write your reasons. I think that's tosh, because if you've actually been able to formulate your reasons, you have in fact thought the case all the way through, and you will have rewritten those reasons many times. And then if you do that at the start, and you repeat it at the end, and you also have this little roadmap we talked about earlier, I think it would be far easier to get your way through cases. It would make them much shorter too.
Okay, if we could have a final question from the gentleman in the 3rd row here, please.
Yes, hi. 2 questions, 2 brief questions. Are there particular scholars in the field of statutory interpretation who you find particularly influential, and do you think it would be useful for law students in general to have a standalone course in that field?
Well, you obviously predicted what my answer was going to be on the second one. Yes, a course on legislative studies looking at the whole of the process of making legislation, because legislation affects us very considerably in our lives and in our judicial work, and it would do in the life of a practicing lawyer. You have to keep on the right side of the law. So knowing how the legislation is made, the conventions on which it's drafted, and how to interpret it seems to me to be a basic part of a lawyer's degree. But it's not done very often here. I think it may be done in Cambridge at some point, but I'm not entirely. No, you're shaking your head, oh dear. Yes, I would have a course, and I think there are probably some good models in the States that one could adopt. And it's becoming even more important with all this confused situation. We have European legislation, we have legislation from the Westminster Parliament, and then from the Welsh Assembly, and the Scottish Parliament, and the Northern Ireland Assembly. One would have thought it would be a really interesting subject to study, however. And then scholars in the field of statutory interpretation. Well, I don't know many. I know there's a very good Canadian, Sullivan, is that right? I'm sure there are some. There is a very big fat book, as you know, called Benyon, which we have in English law, but it writes up statutory interpretation as rules, and really it's more nuanced, as far as I'm concerned, than that. So maybe you could get out there and write me one.
Well, I'm sure you'll all agree that tonight was a fascinating discussion, so if you could all please join me in thanking Lady Justice Arden for coming down to speak to us tonight.